Your hosts have earned a reputation as fierce and effective advocates inside and outside of the courtroom. Both partners are experienced trial attorneys who have been board certified in family law by the Texas Board of Legal Specialization.
All right, this is Jake Gilbreath with Walters Gilbreath PLLC. Thank you for joining us again. And today we're joined by Keith Maples, the managing partner at Nolte, Maples, St. Ledger, Blair. I got that wrong. It's St. Ledger Bryant. That shows how long we've been working together, Keith. Tell us who you are.
Well, it was with. Blair.
Yeah. I still use Audrey for briefing, but she's on her own now. It's Judith Bryant over there with y'all, right?
Yeah, that's right.
All right. Well, let's start off just like we do in court. Who are you and what do you do, Keith?
All right. Well, Keith Maples, and I'm a partner here at Nolte, Maples, St. Ledger, Bryant, and I practice exclusively in the area of family law, or divorce law is probably more accurate, and I have a subspecialty in helping families that have children with special needs and the issues that come up in family law litigation for those families.
And let's talk about that because we're doing a series on divorce and family law matters with children with special needs. Before we do, I kind of want to talk about how you got into that. So, I mean, for our listeners, Keith, I've known Keith since I first started practicing law. He's well regarded as one of the best mediators and one of the best litigators in Central Texas, which is a difficult balance to be able to do both. Usually you have really good litigators or really good mediators. I've tried mediating myself, and I think I'm not good at it. And I don't know what that says about me. But serving as the mediator never really was my skill set. But you seem to be really good at both. So before we get into sort of your subspecialty, how did you develop your practice? We'll talk about the subspecialty in a second, but how did you develop to where you're both a litigator and a mediator, and how do you divide your time up?
Well, one of the things that I really enjoy is doing different things and new things. And I think that you're right. Most folks decide a lane, and or it's decided for them, and they just operate in a fairly narrow lane. When my firm merged with Lee Nolte's firm, 15 years ago at least, one of the things that Lee recognized was, Keith, you do a lot of things. You do collaborative law, you do litigation, you do mediation, and his advice was pick a lane, because I don't think folks can succeed. And not that long ago, Lee and I had a conversation where which is hard for all of us to do, said, I was wrong. You've done a really good job of doing a lot of different things and being good at them. But the thing I like about it is the change of pace. To be able to go from working my cases to putting that on hold and just concentrating and focusing on mediating for other lawyers for a day. And then it's over. And that's a nice break from the files that last for 6 months to 4 years in our offices.
Right. Well, and as somebody who uses you for mediation, it's helpful, I think, to have a mediator that can sit there and say, not only have I heard about what's going on at the courthouse, I've been there and I've seen this happen or that happen or this trend or what have you. And then I'm sure as a litigator it helps as well, being able to bring in that aspect of it. Okay, so enough about talking about how amazing that area of your practice is, but it really is. I mean, like I said, since practicing law, getting involved in practicing law, that's always been your reputation as top of your field for both. But let's talk about the subspecialty, because I know you're known for that and do a lot of work both with CLEs, speaking, and of course representing families. So first of all, how did you get involved with sort of the subspecialty of representing families that have going through divorce or family law matter, and they have a child or multiple children in some instances with special needs?
Well, I have a son who turned 25 this year,
Yep.
Who is fairly profoundly affected by autism. And so I don't try to hide that from anyone. And I mean, we live in a fairly small community when it comes to people that do this type of work. And so folks that know me know that about me. And so I found that I was getting a lot of cases referred to me. I was being hired to mediate a lot of cases with those issues. And I was being treated as if I was some sort of expert on that subject. And the truth was I wasn't. I knew one family and one kiddo and our experience in going through that process of getting divorced under those circumstances and living our lives. And so I decided that if people were going to treat me as if I knew what I was doing, I ought to try to educate myself. And frankly, I went out looking and I didn't find a lot. There wasn't a lot of material out there, CLE stuff that where articles were being written and speeches were being given on this subject. And so I started doing it. And I've had the opportunity to work with a lot of other professionals that work in this area and build a network of those people, and had the opportunity to speak a lot with the State Bar of Texas and some opportunities to also talk on the subject at a national level as well, and try to become an expert, and also to teach other lawyers some of the pitfalls that are not necessarily immediately obvious when you're handling these kind of cases.
Right. Well, let's talk about kind of the interplay. I mean, obviously, having a special needs child, and I talk about it on the podcast some and I think I'm pretty open with our clients. I mean, my oldest son is on the autism spectrum as well. He's moderate on it, and it's something that we've had to deal with as well. Me and his mom, and of course, and his stepmom, and my family, and everything. It's just the treatment alone, right? Is just the amount, the lack of information, I guess, or lack of clarity. And maybe that's not the right way to put it. The difficulty in finding the information out there for a child with special needs is it's a lot of work. And then compound that with going through a divorce or going through a child custody case. So let's talk about sort of, anytime I do a consult, and I know you're the same, or when you mediate, just talk about, a child custody order largely boils down to 3 points: conservatorship, possession, access, and support. So let's sort of take them one by one. Conservatorship, when folks are going through a divorce or going through a child custody case, conservatorship, how does that, the interplay of having a child with special needs, what types of things and pitfalls do you see as a practitioner that families need to be aware of?
Well, in conservatorship or decision making regarding kids, for a lot of families, there aren't a lot of huge decisions to be made. Where are we going to live? And that tends to dictate where our kids are going to go to school. They're going to go to school at either the house that serves mom's address or dad's address. And so education decisions aren't a big deal, but they can be a huge issue with families with children with special needs, where someone's trying to get the resources of the school for their child, and oftentimes these families have disagreements. A common situation that I find is you'll have a proactive parent, someone who wants to go out and find a lot of resources, and then another parent who perhaps is not sure that that's the right path. And they fall in lots of different categories, but that's a big deal. And if an agreement is required, which is the common way for people to make decisions is by agreement, then if one parent is asking the school to provide resources that are expensive, then, and the other parent's agreement is required, then perhaps if that parent doesn't agree, the school doesn't have to devote those resources. So there's a potential for a wedge by the school district. For example, children on the autism spectrum that can perform academically, but behaviorally they have issues, might require a full-time attendant to be in mainstream classes. And so the school is probably obligated to do that, but they don't have the budget for that. I mean, they've got to pay someone a full-time salary to attend to one child, and they're not going to want to do that. So that's a place. And medical interventions and things like that again, for typical kids may come up very often.
Well, it's heartbreaking to see. I'm sure it's both a mediator and a litigator when parents can't get on the same page, but it happens when parents can't get on the same page about, it could be something more detailed, like what services do we do, how much therapy do we do, who do we do therapy with, versus sort of more extreme. I've seen parents, and I know you have, disagree about even the diagnosis, right? That one parent gets a diagnosis and the other parent, at a certain point, sometimes understandably, it's a difficult thing whenever you get that diagnosis at first, going, oh, that's surely this doctor has it wrong, not my child. But I see parents litigate as basic as over whether or not this child actually has a diagnosis. One of the first cases I did, it was with Jim Piper. Actually, John Barrett was on the other side back when they used to really show up on the other side, which is always a good experience. But parents were fighting over a child's diagnosis. The poor kid was 12 years old and bipolar 1, and had been institutionalized a few times. Had a trained psychiatrist who had done a great job getting him stabilized, but just had that situation. And Mom lived in Austin, Dad in Houston, and Dad saw the kid once a month and just came in. It's like, I don't think he's bipolar. I don't agree with this diagnosis, which actually led to just to tell a side war story. One of Jim's better, surprisingly good deposition questions that you don't expect such a good answer for. But Jim asked in deposition, do you disagree with the psychiatrist's diagnosis of your son? And the dad said, yes, I disagree. And Jim, as a good trial lawyer, asked a follow-up question, which was, what is your child's diagnosis? I don't know. Okay, so let me get this right. You can imagine how much Jim enjoyed that answer. Let me get that right. Get this right. You disagree with your child's diagnosis, even though you don't know what it is. That's right. But that led to the consequences, I guess, that sort of leads me to talk about the consequences of parents disagreeing. Because it's like you said, a lot of times we set parents up as joint managing conservators, and which doesn't necessarily mean we make decisions jointly, but a lot of times court orders say that. And that results in one parent maybe having the veto power. We'll talk about modifications and how to fix that down the road, but one parent has the veto power. So, folks are divorced, let's say they're true joint managing conservators, they had to make true psychological or psychiatric or educational decisions, and then the child gets diagnosed and one parent goes, nope, don't think so, and I'm not going to agree to any treatment. That can have horrible consequences on a child. I'm sure you see that both in mediation and in litigating your cases.
I do, and you have the two ends of the spectrum. Okay, you have that problem when decision making is done by agreement, requires agreement. And that's the way I explain it to people coming into my office. It sounds really good, but it really is veto power. And that's the way I approach it with my clients, so that they understand that. And like I said, in typical cases, it may not be that huge an issue. There may not be that many decisions. But the other end of the spectrum of giving exclusive decision making to one parent disenfranchises the other. And that's a really harsh reality. And in a lot of families, and I'm just going to, stereotype a little bit, where you have one parent that does most of the parenting obligations and the other one is making sure that there's enough income coming in to support the family. The view that those two people have of the same situation can be very different. One is deferential to the other because they're more actively involved, but they do feel like they are involved. And post-divorce, they still want to be involved. And so so they don't want to have no role. I'm a big proponent with families like the ones we're talking about here of arbitration clauses, especially if you make the process one that is not going to be incredibly burdensome. And pick
so talk to us. What does that look like, an arbitration clause, when it comes to conservatorship?
Well, what I like to do is have the arbitration. If the parents need to agree and can't agree, then they can have an arbitrator come in and make that decision for them. And in those situations, it's not like litigating where we're modifying the whole order. We have a decision. We can't agree. And so you come in, you meet with that arbitrator, probably informally in a conference room or on a Zoom or some sort of video conference, and maybe you spend a couple of hours on that, present your case, and then the arbitrator decides. And so instead of having months-long, protracted, expensive, lawyer-intensive litigation, you go approach it that way. I've done those things where I don't ever even interact with the lawyers. I have the parents come in, we talk about it, they pitch their case, and I make a decision. And they stay involved. Whereas at court, if parents have to agree and they can't agree, the change that the court, I believe, has to make is give that power to one parent or the other. And so being wrong about one decision in that judge's mind might mean you lose the vote on all the future decisions, which seems in my opinion, fairly crummy way of solving the problem.
But in perfect world, right? Yeah, we have a whole podcast where we talk about special judging and arbitration and the benefits of it, and that's perfect example for. I think that case I was talking about a few minutes ago, that was a modification, right? They spent 4 days in trial in front of poor Mark Silverstone when he was on the bench before he passed. Listening to psychiatrists come in and testify, and all these providers and stuff, and horribly expensive for the family. And frankly, they could have short-sheeted if they had just gone to arbitration on that. Talk about tiebreakers too, because I tend to avoid. I sometimes think, and I get why we do it sometimes in mediation, but it seems like sort of the lawyers sometimes at the end kind of throw their hands up and just go, well, if the parents can't agree on psychological or psychiatric, then they'll just, the kid's pediatrician will decide or something like that. What are your thoughts on having built-in tiebreakers like that in a divorce decree or custody order?
I don't think they practically work. I don't think any medical doctor is going to make a decision for any family. I don't think their a malpractice insurance company wants them doing that. And frankly, I just don't think they will do it if asked. They may make a recommendation, and that may be a more practical way of approaching it. But even with that, my experience is doctors say, here are your options, and here are the pros and cons of them, and then they ask the patient or the family of the patient to make those choices. You can make arrangements where we're going to put the child in therapy and we're going to continue that therapy unless we agree otherwise, as long as the therapist is recommending it. If you pick the wrong therapist and you give them control of when it ends, then you may have created a retirement plan for them. Some people may need therapy forever, and some people may very well not. There are certainly some mental health conditions that require medication and treatment and constant work, and you're going to be in therapy forever. Other people, it's situational.
And that's one thing and sometimes it's not a clear recommendation, like you said. One thing I don't know if surprised is the right word, but discovered shortly after, my child had his diagnosis was, it's going to be, they'll say, well, think about this, or maybe try that, but there's no bright line from any of the medical professionals saying, you shall do this. This is what you have to do for this child. There's examples where that is the case, but there's a lot of things in raising a child where, that's just, here's, think about this treatment over here, or see how your child reacts to speech therapy or OT, or maybe it's time to try ABA. Maybe you should do this school or that school, and it's just not. And then we're back to where the parents have to decide. So I think the arbitrations are really a really good point to sort of try to keep families out of the courthouse.
And those therapeutic interventions, some of them are transformative. I mean, some kids engage in those therapies, and then you flash forward a few years, and you don't even, other folks wouldn't even know your child is on the spectrum. Other families can devote a huge amount of attention to that, and maybe it improves things, but it doesn't, put the child on a path to ultimate independence.
Yeah. Well, talk to me about, so we talked about conservatorship. Obviously, we could spend hours talking about that, but talk to me about possession and access. Do you see, as a mediator and as a litigator, it's so easy to just say for families, standard possession order, or 50-50, 50-50, whatever, people are would be talking about when they don't have a child with special needs. How can, the interaction of the special needs and that with the possession schedule, how do you see that play out in your practice?
Well, it comes out in a lot of different ways. One of the things that you want to look at is, and especially with some kids have such medically sensitive situations that the first thing you want to explore is, does the non-primary parent have the skills to care for their child? Another thing is, do they have the resources to care for the child? And with a lot of families, say you have a wheelchair-bound child, and then, is there special equipment? The vehicle, like the state will often provide for some families a wheelchair van, but they don't do two. And so sometimes you need to make sure that the equipment is going back and forth. Some kids are on, special diets, require things, and so you want to make sure that the parents are capable of doing it. So that's one thing that comes up sometimes. Another issue that I think is worth looking into, when you have multiple siblings and you have a child with special needs, we as family law lawyers always assume the kids are going to be together. It's an incredibly rare situation where kids are on different schedules. Sometimes when their ages are very different, we've done that. It makes sense. But also you might want to look at a plan where the child with special needs doesn't have the same schedule. Divorce is a sad circumstance, but sometimes it provides opportunities. In my personal experience, having our son in one home and at a time gives each parent a break. We provide built-in respite care for one another. And when he was younger and more challenging to parent, that was really important. And so that's a consideration. And one of the things that, especially at the initial outset, we don't know what schedule is going to work. And a lot of people are afraid of those schedules. And so one of the things, if you can do it, that's nice, is to experiment. Let's try a schedule, see how it works. Now, when you're litigating everything, it's sometimes really challenging to change a schedule on a temporary basis if you keep having to go back and ask the judge to do it. But if parents are open to it, that's an opportunity to come up with something that will work.
Well, again, more reason, if you have an arbitrator that is with a family, that can kind of help the family get through it. And again, this is, I tell folks whenever they're going through this, just because we're building this structure doesn't mean that we're going to use it, right? Some parents,
right,
they get on the same page with treatment from, the diagnosis all the way. I mean, it doesn't stop when the child turns 18, but, and we'll talk about actually that in a second. But it's, gets them all the way through high school or whatever, and they don't need that. But the importance being is, if you get stuck, because it's hard being a divorced parent as is, it's more challenging being a divorced parent with a special needs child. If you get stuck, that could be Doesn't necessarily mean that sometimes that somebody's a bad parent. Sometimes it does. Sometimes you have folks that just have difficulty seeing what's best for their child, but sometimes it's just good faith dispute. One parent thinks this is the best treatment, one parent thinks that is, or this is the best possession schedule, or what have you, and they just need a decision. And so that's helpful. Let's talk about
one of the things.
Yeah, go ahead,
Jake. I think we ought to mention for the lay people that might be watching is we're talking about these options like arbitration. And we need to let everybody know that that's only an option if everyone agrees to use it as an option. That is not something that you can go to court and ask a judge to impose. They can make you go to mediation, but the court doesn't have the power to appoint an arbitrator unless the parents agree that their disputes will be submitted to arbitration.
And it's an important decision. So that's right. Or before signing on the dotted line, saying this will get pulled from the public courthouse, that system, and go to arbitration. That is something to remember for parents. And frankly, anytime you decide on an arbitrator or a special judge, you have to put a lot of thought into it. Make sure you talk to your lawyer about it, because that could be your decider from now. If you're the arbitrator for one of my families, it's, as a practitioner, and we talk about this in our other podcasts, as a practitioner, sometimes it's nerve-wracking to do that because let's say I tell my client, look, let's have an arbitrator decide this. Keith's he knows his stuff, and Keith's going to decide. And as a practitioner, it can be difficult to recommend that because let's say, for whatever reason, the client disagrees with what the arbitrator does, which isn't surprising. It's rare that everybody sees it 100% one way or the other. Sometimes it happens, and then they're looking at their practitioners. Why'd you recommend Keith? He totally missed the ball on this issue. But I think as practitioners, our job is not just to. The easiest thing in the world is to put your head down in the sand and just say, let's just have a judge decide, and it works out well for you. It's out of my control as a practitioner. You can't criticize anything that I've done. But I think, particularly at the level that we do it, we owe more to our clients to have these discussions about other options, even if it does, not always work out but on balance, this is a more logical way to proceed with your family. So let's talk about support. We've talked about conservatorship, talk about possession access, talk about support. So, and we've sort of touched on it a little bit in these other areas, but obviously you see special needs. It can be a financial burden for families. So how does that come up in mediation or litigating your cases? What are the financial considerations families have to talk about? And what can the court system even do for that?
Right. Well, let me hit a couple of super important points on the support issue. First of all, Texas is among the vast majority of states that provides for support beyond adulthood or into adulthood. I did a presentation a few years back on this subject, and at that point in time, I think 43 states had some form of support for an adult child with disabilities. In some instances, it was child support, sometimes statutory, sometimes the courts found it, other times it was a component of the alimony in that state. And so we have both in Texas. You can get alimony and support for an adult with disabilities, and the parent caring for them can. It's very important if you have a child that is an adult or will be needing support as an adult, to put in a provision that provides that support can be paid to what is called a Medicaid or Payback Special Needs Trust. And that way, the receipt of child support by that trust won't count as income for that adult with disabilities, and so they can still get Social Security, SSI benefit, and get support for their needs. So that's that's a very important component that we need to be wary of, because if you don't address that, then your family can have a lot of problems, and they can usually be fixed, but it's embarrassing. The other thing that I would say is, as soon as you know my kiddo's probably going to need care for the rest of their life, then in Texas you need to get your kids signed up for some of the waiver programs that are available to take care of that care, provide for that care, because the waiting lists are about, I think at this point, 15 years. And so if your child has a disability, go ahead and sign them up. If your kid grows out of it, so to speak, in some way, or can become independent, then you just say, no, thank you, I don't need it. But that's a lot better than having someone who needs it and finding out you're not going to get it for 15 years. And so the guidelines, are there, they exist for child support, and it's a fact, take into consideration the income of the obligor, and but there are a lot of the factors for varying from the guidelines that I think are very applicable to situations where you've got children with special needs. And so I think I've had a lot of success in representing people who are seeking more than guideline support in accomplishing that. Now,
the hardest cases are there's only so many dollars sometimes, though. I mean, and you have to make that balancing act of, sometimes there's treatments that would be life changing for your child, and it's just outside a family's budget. Those are really, really hard cases to deal with.
Absolutely, and there are cases where normal folks, upper middle class income, single wage earner, divorce is coming along, and they could do a arrangement where we live in one house and one of us works and the other one takes care of the family and our special needs kid and everything. But when you all of a sudden need two homes, and add that and all of the other expenses that come with living in two homes, that breaks the back of most families without special needs children. But working outside of the home when your kid needs constant care might not be possible, and those are really, really hard cases to resolve.
Yeah, they are. Well, let's talk just briefly about modifications, and then we'll wrap up. So let's say I have a divorce decree, and it's let's say we get divorced and the child's younger and doesn't have a diagnosis, and maybe we're true joint or what have you. One parent runs the show, whatever, and then they get the diagnosis, and the divorce decree doesn't work anymore, or is not appropriately addressing the needs of the child. So what do we do in that situation?
Well, I think certainly a diagnosis that drastically changes what the needs are of the child and what the expenses are going to be for addressing those needs, it wouldn't be hard to establish that that's a change in circumstance. And so the court has the ability to modify the order to meet those needs.
Yeah, and that's I always tell people when I'm representing them, and particularly with younger kids, right? I say we're trying to build a court order that lasts till your child turns 18, or till they graduate high school, or with regards to support. But things could come up. I mean, I do tell people when my son was younger, whenever me and his mom got divorced, and we didn't have the diagnosis yet. And we got the diagnosis about a year after our divorce. And I mean, we were real fortunate that we've been able to get on the same page and sort of address that head on together as co-parents, even though we're divorced. But if for whatever reason we didn't, and this is what I tell my clients, let's say we got my son's diagnosis and I stood up and said, don't agree, don't want any treatment, and his mom said, no, I think we do need treatment. There's a mechanism, right? It's not like we're just stuck. And obviously, nobody likes calling lawyers and going to the courthouse or arbitration or what have you. But sometimes it's necessary, and that there's a path forward. It's not like you're just stuck and you can't do anything about it. And the family code provides for that. So these are just sort of very, very moderately touching on these really in-depth subjects. But to wrap up, first of all, I want to hear about the work that you and your wife do outside in the community. And then we'll wrap up with your contact information so people... but tell me about you and your lovely wife stay involved, I think, out helping families outside of just the practice of law. Your wife's a lawyer as well, so make sure to talk to us about her. But what do y'all do as far as giving back to the community?
Well, your wife, my wife, are on the board of Imagine a Way. I was on that board for probably about 12 years, and Sarah joined. Your wife joined while I was there, and I kind of got to the point where I thought it was time for me to move on and bring some new energy onto the board. And so I talked to the board, and I talked to Nikki, my wife, and she's taken over since then, and it devotes a lot of attention to that. And Imagine a Way is a charitable organization that, I describe it as sort of like there's the Medicare donut hole, certain things that Medicare doesn't cover, and so you can have supplemental insurance for that. Well, if your family is well off and has lots of resources, then you can pay for whatever your kid needs. And I was lucky enough that was available for my family in helping our son. Or if you're poor, Medicaid is actually an incredibly good program to take care of a lot of these care needs. But if you're normal and you have normal person's resources, then when your kid is prescribed 40 hours of ABA therapy a week, plus speech, plus OT, plus PT, most insurance doesn't robustly cover that. And so Imagine a Way steps in, and we sponsor a family, and we cover it all, whatever insurance doesn't cover. And so we've been doing that here in the Austin area for probably, 15 years now or so. And think that we may have just recently sponsored our 100th child. And that organization covers those therapies for kids from about 2, which is about as early as you might get a diagnosis, up to about 7, and helping those kids in that regard. And one of the things that I think is incredibly cool, and your firm has done a whole lot to help support, is, and this was sort of one of my pet projects while I was on the board, was expanding Imagine a Way into other communities. And we're now expanding that program into Houston. And some of our friends are very instrumental to that, and your firm is supporting that since y'all have offices in both cities. And so that's what one of the things that we do and put a lot of time into, and that I'm really proud of.
Oh, you and me both. And you actually were the one that invited Sarah to be on the board, so that's that is such a joy in our household to be able to help out, and it's just watching the work that they do. And when I say life-changing, I mean life-changing work that they do for families. It really is a blessing. So to wrap up, Keith, so if somebody wants to reach out to you or contact you, obviously they can Google you, but also what's the best contact information for reaching out to you or any of the skilled lawyers that you have at your firm?
I think just call the office, 512-480-9777, or, if they have just some question, or, also I do a lot of consulting. So if somebody has a case, in Lubbock or Odessa or El Paso or Houston or Dallas or whatever, reach out, tell your lawyer about me. The email address for me is kmaples@nmsb-law.com. I get contacted all of the time. Sometimes it's just to answer a simple question. A lot of times a lawyer will reach out to me. A lot of times a client will say, hey, I heard about this person. Why don't you consult with them? Make sure that we're not missing something here, or get some guidance. I'm always happy to do those types of things. And sometimes I get paid to do that. Other times I just take a call or respond to an email, and I'll just do that gratis.
Yeah, well, we appreciate you doing that and all the work that you've done. So thanks for joining us. And for more information about the topics covered in today's episode and more, you can visit our website at waltersgilbreath.com. So we got Keith's information, which we'll also post in the description. Thanks for turning into today's episode for Better, Worse, or Divorce, where we post new episodes every first and third Wednesday. If you have a topic you want us to discuss, or feedback, or any questions for us, just email us at podcast@waltersgilbreath.com. And thanks for listening.
For information about the topics covered in today's episode and more, you can visit our website at waltersgilbreath.com. Thanks for tuning in to today's episode of For Better, Worse, or Divorce, where we post new episodes every first and third Wednesday. Do you have a topic you want discussed or a question for our hosts? Email us at podcast@waltersgilbreath.com. Thanks for listening. Until next time.